Good afternoon, everybody. Let's make a start. It's a pleasure to see so many familiar faces here in room 1. So in case those of you don't remember from first thing this morning, can't remember that far back, my name is Logan Rathful and I'm the Family Law Co-Chair here at FOLA. This is our first breakout session out of 2 here in room 1 with our AI theme. So this promises to be very interesting. Just like to take a brief moment to introduce our first breakout session here in room 1, Get an Edge, AI and Legal Tech Tools. So our speakers for this afternoon in this session are Jordan Atten, Counsel of Hull & Hull LLP, Poulat Yunusov, founder of Yunusov Law, and Scott Rollwagen, partner of Lechner Slott LLP. All right, take it away, folks.
I'm just gonna. Well, it's a pleasure to be here. Thanks very much for the invite. And my name is Jordan Atten. I am a full-time estates lawyer, and I'm a full-time CEO of a software company, which makes it a little busy at home. So I have a kind of a unique story, I think, somewhat. I've been practicing estates for 30 years, and in our area, really, it hadn't changed in hundreds of years. It was the same practice and same process that we were using to meet with clients, to take instructions, to make sure we didn't miss an issue, to draft documents, and that really was exactly the same. If you were in 1830, or in 2020, you were using the same process. Private notes on a piece of paper, asking the client what they want to do. And that's how I did things for 20 years. And then in my business, we evolve every couple hundred years. There's something new. And so we used a whiteboard to do this, to draw it up. And then I thought, wow, that's so advanced. But a colleague said, well, why don't you try digitalizing it? And so we created, Ian Hull and I created eState Planner for our own practice. And I'm just gonna show you a quick demo and I'll talk over it. But the whole philosophy of this was to take a process that was purely verbal, because we as lawyers, we love words and we think everything we say is understandable to lay people, but pictures work way better in my view. And so what we did was we digitalized and visualized the entire process, while building in things to make it safer for us and more efficient. So I'm just gonna press play here. This is a family tree. So rather than just asking the client about their family, this is drawing a family tree. And it's identifying disabled people and people who are estranged. And then it's collecting all the asset information and automatically calculating probate tax and income tax and things like that. Again, sharing this visual with the client, they can see their family, they can see their assets. The other thing we can do, because we're using data, we can actually demonstrate to the client the impact of certain decisions. So if we do this, this is how much is going in this way. This is how much is being saved in probate tax or income tax. And then we can drag and drop assets around. And it's a great process for the client. First of all, that's kind of cool, but we can actually show them, listen, if we do this, this is what's gonna happen. So it's all about making sure that the client and the lawyer are on the same page. And that's the idea. We're sharing our screen with our clients to see that. The other thing is, right now, every lawyer has to keep their checklist in their head for every kind of gift. Oh, I better remember to ask about this. I better remember to ask about this. eState, if you're creating, happens to be a house trust, you go through this checklist, everything is there. If you click it off, then it's gonna work, it's gonna draft it. And if you do something wrong, eState's looking at all of the data and the law and practice and warning you, oh, you screwed up here, Jordy. You should have done this, you should have done that. Did you ask the client about that? Right now, we have to keep this all in our head and we have to correlate the data with our knowledge. It's a very difficult thing to do and it's easy to make mistakes. And then, rather than sending the client a draft that's 20 pages long that nobody understands, including most lawyers, we translate that into a picture. This is Homer Simpson's will in a picture. And I've never had a client, and I've used this over 1,500 times, never had a client say to me, that doesn't make sense to me. Now they leave, the client leaves. Don't do this in front of your client. I click a button, it drafts. Whatever I did in that, as complicated a plan I did, it's going to create a draft that spells names right, puts the right clauses, doesn't forget things, which are really easy to do. And so that's what we did, and we're pleased to say that we're part of the Law Society's Access to Innovation program. We're thrilled to be part of that. We have hundreds of firms across the province, 340 at last count of firms that use eState. And the great thing is we're centralizing knowledge. So we take our precedents and we get input from all these different lawyers, from all these firms, and we're sharing the knowledge. And we hope that it's making the process safer and better for us as the lawyers, and certainly a better client experience, because we're going to need to up our game as lawyers if we're going to compete in this coming decades. So thanks very much.
Wow, that's I don't know that I could follow that very easily. I'm here to talk about a product we use at Lenzner Slatt, and again, we didn't develop it, so you know, kudos to Jordy for all the work on that incredible service that he's providing. We've started beta testing a service that a startup is using, and they've been around for a while, called Alexi. And the function of this service is to do basic level case law research. It's kind of a co-pilot that you would use to assist you in doing case law research. I've been around long enough, you know, I've been a research lawyer since the 90s, and I remember the days of having to crawl through the Canadian Abridgment and the Empire Digest. And you know, two things have happened since then. Obviously, information has become digitized, easier to access. But also, I think, you know, the law is kind of dissolving categories in a way that's, I think, accelerating. So sometimes, you know, you'll get legal problems that arise very frequently in a busy litigation practice that just collapse categories. And you're not going to be able to pick up the book and say, okay, what's the answer to this? And so this service is designed, you know, to deal with these kinds of interstitial issues. And frankly, our experience with it has been excellent. And the, you know, just to give you an anecdote about the first kind of encounter I had with this service when we were kicking the tires on it, I thought I had a particular issue about, you know, directors' obligations to make disclosure when they're interested in a contract with the corporation. I thought he'd be an interesting one. Let's try to throw a curveball to this AI. How granular does the level of disclosure of a director who's interested in a contract with the corporation have to be? And that's the question, goes in. And this was using their Pro Memo service. Memo came back was pretty good. It cited the leading, you know, Privy Council case, the Porcupine Mines case, that has, you know, the basic thing that you would go to and note up and find other cases that cite that. And I thought that was when we really stood up and paid attention. Because that's a kind of sophisticated thing where, you know, it's not going to go to some index and say, okay, here's the answer. This was done using, you know, large language model technology that got a very, very decent answer. And they've evolved their service quite significantly, and to the point where it's something that has become a great place to start with research. So there's another product that they've developed that we've used. There's really 4 of them, or you could say 3, but one is just a subset of, or there are 2 aspects of the same service. There's the memo service, which has these pro memos, which, you know, generated the answer that I was referring to, and these are curated by lawyers. So it's not a lawyer out doing research, but they kind of police or ride herd on the AI to generate a more polished product. There's a second product that they have with respect to memos that we're using that I find very, very helpful, and it's an instant memo service, which is, again, a great brainstorming co-pilot. You know, you put questions into the service like that, and it will generate, you know, a kind of, the way I would describe it would be the kind of memo an articling student, a decent articling student would generate if you gave them an assignment and said you've got 3 hours to do it. This will get you that answer in minutes, and is, you know, is canvassing a little bit more of the landscape of cases that are available. So again, the answers don't come back perfect. It's just a co-pilot, but it's a great area to start brainstorming about cases that may be helpful. And there's almost never a situation where I'll put a question into the service and it doesn't provide for me an answer that will stimulate some kind of thinking. So those are the kind of memo services that they provide that we find very useful. They also have a couple of beta products that we're using, and we're testing those out as well. The first is called Arguments, and it basically is a service that helps you brainstorm arguments. If there's a particular outcome that you want, you know, you either have to draft a factum or you even have to think through the theory of your case, this will brainstorm for you different perspectives. You know, have you thought about disgorgement? Have you thought about arguing, you know, that there's a trust? And those are great little things that can tweak, oh, geez, maybe not. And then you can start generating different pathways to start to solve more complicated problems. The third service that they have is just called Chat. And it works a lot of the ways that I find, you know, speaking to in-house counsel, the AI services that are out there, Alexi isn't the only one, but it's great for, oh, geez, you know, give me some language for a release, you know, to settle this kind of case. And it will generate a pretty good kind of ChatGPT 4 level, again, something you could use as a baseline brainstorm to think, oh, okay, because it's a great sort of thing that you can look at and say, ah, okay, oh, but that doesn't actually apply to me. But then you can play with it and make it your own. And so these services I find are great at kind of getting rid of the activation energy. Like if you've got to start a task, and oh, geez, and it's a great way to sort of get you going and give you ideas and put you off in a direction. And it really speeds up that internal inertia that we find when we're doing complex research.
Thanks, Scott. Thanks, Scott. Your point about growing complexity of law and legal research has really resonated. And you talked about the specialized AI tool for brainstorming legal research or for generating legal memos. I want to talk about a more generalized AI tool and its use in law practice, such as ChatGPT. And of course, we've all heard probably about how ChatGPT hallucinates about case law. So while we approve perhaps some specialized AI tools such as Alexi for legal research, very reputable firm is using it, but using ChatGPT is probably not approved for legal research because of the hallucination reputation. But I want to talk about something else. I want to talk about how we can use not a $500 a month tool, but a $30 a month tool for something still very important in law practice. Scott talked about the law side of law practice. I want to talk about the facts side of law practice. And ChatGPT is actually pretty good at generating responses about the facts of this world. Not the facts of your case necessarily, but how much of your law practice is spent thinking about cross-examination questions, thinking about the domain of your case. For, let's say you're working on a construction case. Even though you're not an engineer, you're still supposed to know a little bit about construction or a lot about construction to ask the right questions on cross-examination, for example, or even to prepare your client for examination for discovery or for direct examination at trial. You should know something about construction, even to brainstorm issues. What issues are raised by this case? And you know what, for example, I used ChatGPT to generate an image of an element of a building. And then I sent that image to my expert. And I asked my expert to tell me if this was the right idea of what the expert was talking to me about. I asked ChatGPT, I gave my understanding to ChatGPT, it generated the image, I sent it to the expert, the visual worked, the expert said, this is it, right? So, or also when you prepare to cross-examine an expert on his report, then of course you can also learn more about the domain, the specialized domain from ChatGPT, so the facts side. And we know that very often facts are more important than law. And the generalized AI tools, I feel they're quite ready to help us look into the fact side, into the domain side of our cases. Thank you.
I think we're going to turn in the next session to basically ethical issues and some objections that we're seeing with technology. So
yeah,
do you want
to? I can start. So imagine you have a client who is quite sophisticated with technology, quite sophisticated with AI. So I recently heard about this design conference in Toronto. It's called FTIC. And it basically brings designers, graphic designers, computer designers together. And one of the ideas there was that everybody today is a designer, and they put low effort designer, low effort in parentheses before the word designer. Can we say in the same vein that everybody is a lawyer? At least everybody thinks that they're a lawyer because they go to these AI tools and they ask questions that they used to ask lawyers before. And then they send these answers to us, and they tell us, well, what do you think about it? Or they ask questions about documents, which is maybe even more relevant and more common. They would, you were served with a motion record, you shared it with your client feeds it to the AI tool and starts asking the AI tool, which some PDF software now have, the built-in AI prompt, the AI assistant. Start asking that PDF software questions about this motion record. And then they tell, why didn't you think about this? Why didn't you ask them this question on cross-examination? So there's a couple of ethical considerations arise here. First of all, doesn't this create an obligation now on you to use AI tools in the same way if they have access to them? And the second ethical consideration is when a client generates, or his AI tool generates, a long report on an issue on which you're also working. Do you have an obligation to read that report and give your client advice and opinion about this report, even though it's going to cost the client extra in fees and so on and so forth? Or do you have an obligation to use another tool to vet this report? So those are a couple of ethical issues that I thought about. And as usual, the best friends of an ethical lawyer are notice and effort. So we have to... We don't skimp on effort, and we don't skimp on notice. Give plenty of notice to the client if extra fees are anticipated. Give notice, and then also you have to make effort. You have to think about it. You have to turn your mind to it. You can't be lazy about it. This is the reality. Clients more and more are going to turn to AI tools and are going to hold you to the standard of the AI tools, not some vague standard that LawPro has for lawyers, but the standard that clients have for lawyers. Thank you.
So I'm just going to talk a little bit about objections that we see that are brought to us by lawyers about technology in our space. You know, it's kind of classic objections to software. One is I like my old way better. Well, of course you do, because you're used to it. The problem in our business in the States, and I don't know how many are in that area, is we kind of rely on the Wizard of Oz approach. We go back here and we do stuff, and then we come out and it's not, the clients think we're doing something, and really a lot of us are cutting and pasting from prior documents and not really adding a lot of value. And so, you know, yes, the current process works for you as the lawyer maybe, but it's a horrible experience for the client. And the reality is that we no longer have the competitive advantage of we know all the answers. They can find out the answers pretty quickly. And we're going to see in our area, we have competitors where it's direct to consumers, where consumers can go directly and do their own will. If lawyers don't recognize that, you know, we have to add more value than cutting and pasting, we're not going to get paid for that, and we're going to be out of business. But a lot of lawyers the reality is they're used to it, and they don't want to change, mostly because it requires an investment of time. And that's what we're seeing, where, you know, lawyers are, oh, I'm too busy to learn the software. I'm like, well, okay, but you realize that I can do your job in a third of the time, and if you put in, say we have to do 12 hours of CLE, right? If you put in 12 hours to learn a piece of software, you'd be an expert at it, and it would save you, you know, maybe hundreds of hours. And you try to get that across to lawyers. I mean, I'm not that successful, I have to say. But we try, and you know, our motto at eState is I'm trying to keep lawyers in business. We could easily go to the consumer and do that, but we do add value, and we need to demonstrate that we add value rather than just saying, well, we're the Wizard of Oz, so you got to listen to us and you got to come to us. It's not going to last.
Do you find, Jordan, like it's an interesting point you make, because some of the things I've heard from people trying to develop AI products for lawyers is that sometimes big firms have this kind of, well, what are our juniors going to do? Yeah. Like there's this don't give them shovels, give them spoons kind of way of doing things. Do you find that you experience that, or you get pushback that way too?
Well, sometimes clerks are concerned about it. People are like, well, I don't like it. It looks too simple. How are we going to get paid if it looks so understandable? Like, yeah, that is not going to work anymore. And I've never had pushback. In our business, we typically charge flat fees. My fees have gone up. It just takes me much less time. And the clients, they rave about the experience. They're like, wow, I understand what's going on. This is amazing, And they don't expect it to be cheaper. They're like this is a great process. So,
yeah, nice. Yeah, I mean that really resonates, because one of the things that as we work on helping our people use AI responsibly to solve legal problems is exactly that. And I think from my perspective, sometimes I think some of the limits of AI actually are aspects of the problem that will solve themselves, because one of the things that no large language model is going to be able to do is, well, that's a confident prediction. Right. Has been proven wrong. But there's the taking the analysis and the primary sources in the research and taking it the last mile, and integrating it in a thoughtful way with the arguments you're going to make. And we have a litigation practice, so it's all about developing arguments. But one of the things when I first talked to the Alexi people that really resonated with me was, frankly, it's a book, a little-known book that Professor Wadhams wrote that's I commend to a lot of people, and it was written in the early 2000s, like 2003. It's called Dimensions of Private Law, and he kind of anticipated this last mile issue, because it's a sort of meditation on that old 19th century case of Lumley and Wagner, the famous one where the opera singer breaches her contract to sing for a particular opera house. Court's got a problem. You can't specifically perform a personal service contract. But you can grant an injunction preventing her from singing for the only other one. And Wadham's point in discussing how private law works and evolves is that if you loaded all of the case law, every bit of jurisprudence that existed up to that time into a supercomputer, it would not have predicted that result. And that's some of the reality of large language models, because it's also easy to forget that large language models aren't AI. I mean, all large language models are AI, but AI is not all large language models. The Venn diagram is different. And so the really interesting thing about that is, all that a large language model can do, even though they have strategies, stuff that's built into the algorithms to prevent them from overfitting the data, the only thing that a large language model can do is to sort of give you the state of play as things are right now, as the law has developed. But it's like people say, if you trained an AI on everything that was, all the knowledge that existed before Copernicus, it would tell you that the Earth was the center of the solar system, because it's limited by its data. And it's that dimension of, the law evolves through experience with particular cases, and that last mile always involves the particular case. The law is what the court is going to do tomorrow. And right now anyway, there are very few, there's no AI that I know of that can help solve that creative aspect of the problem.
Well, with respect, Lenzner has a survivor bias, because it works on such large cases much more than many other firms. The vast majority of cases in the courts, they involve a pretty straightforward last mile, I would say, and do not require conjecture beyond what's already been done. So for most litigation, I think LLMs can pull it off, but you're right, the cases that some of our friends at Lenzner work on, some of these cases, they do require incredible originality and conjecture and proposal of new policy sometimes and things like that. But for the most part, litigation, I think still litigators are safe. Despite what I've just said, I think litigators are safe because we all know that litigation depends not just on law or facts, it also depends on reputation, it also depends on the gravitas, it also depends on who you are. So as long as judges are appointed from among lawyers, judges will listen to lawyers rather than to machines. This is my humble opinion.
No, that's an excellent observation. And you know, it is the case that we can't just think of the stuff that people in the ivory towers do. It's the on-the-ground experience of regular cases.
Yeah, and this is why we're getting these practice directions requiring disclosure of any AI output in your submissions, because judges are very careful to segregate machines from lawyers. They still want to listen to lawyers. They want to listen to the human perspective, to the professional perspective, to the perspective of those who are informed by the rules of ethics, who are informed by their status as the officer of the court. It's a system. We're all part of the system. So the system values us.
I just wanted to mention just AI and the large language models versus, so, you know, our area is, you know, hundreds of years old. We use the same language. We actually don't want it to be generative in a sense. We want it to be the same every time. But and I don't know if it's this way in many different areas, but we're very rules-based. Yeah. I mean, we know the rules. We don't need to, you know, as long as we enter them and we find them, then we know what the rules are. And so, you know, I wonder, you know, certainly I think a software company that's going to consumers might want to use generative AI, but in our area we use a lot of algorithms, but they're rules based and as opposed to sort of generative. You know, so
like tax preparation software.
In a sense, now we have that's right. We can't think of everything. That's what we tell our, you know, we say like, you know, no software is going to be perfect, but it's very rules based in our area for sure. Yeah.
Any questions?
Oh, there we go. Thank you very much to our distinguished speakers. If anybody has a question, just stick your hand up and wave it around like crazy, and then we'll pass the microphone to you so that we can actually get it picked up on the audio.
This is your only chance.
I could start with a question. This is, I guess, directed to you, Pula. You mentioned the hallucination effect of AI. Could you explain what that means?
Yeah. So the hallucination effect is a technical term. It's a term of art. It means when AI, such as ChatGPT, generates output in response to your question and pretends that it is the correct output. So it will make it sound like it's completely legitimate. It will invent, for example, a citation. It will invent a case, and it will not give you any notice that it did so. It will not tell you that I just invented it, because it's not capable of giving you such notice. It cannot distinguish between truth and falsehood. This is not within the capabilities of LLMs. LLMs work by using statistics to predict what the next character in the output is going to be. So to the LLM, it perfectly finds, perfectly well satisfies its program, its algorithm, but to you it's a professional discipline matter.
And that is a real thing. Like, I mean, one of the things we do is we play around with ChatGPT to see how it would deal with, you know, legal issues. There was one question I asked a ChatGPT, that would have been 3.5 at the time. It hallucinated a case. It created a case that did not exist. I looked and looked and looked and could not find this case. And it turns out it was a complete hallucination, a total fabrication. At a less, you know, shocking level, it'll also just get basic things like, what was the outcome? Summarize the case of Hercules Managements and Ernst & Young. It got the result wrong. It completely got the result in the wrong direction. And it's you know, and that's simply because it's, you know, all it's doing is, as Poulat says, it's working on statistical probabilities, but it doesn't know that there was a case out there and what it means for somebody to win and somebody to lose.
What was interesting when we were looking at AI in our software is it was great at pulling data out. It was not good at logic. It can't really do logic. Yeah. I'm like, can't it just tell me it's this executor, then this executor, then this executor, if that guy? No, we can't do that, but we can pull the name. Like, I was amazed at that, and it made me feel a little bit better, actually.
It doesn't, I mean, one thing that I've noticed, and you can comment on this if you'd like, is it doesn't seem to be very good, at least with GPT 3.5. That's all I had experience with. I've not gotten into the 4.0. But if you respond to it and say, no, that's incorrect, and the reason why that's incorrect, and then you give it the logical reason why, it'll often come back to you and say, oh, I understand the oversight now. Thank you for bringing that to my attention. And it'll still give you the wrong answer. So is that the same as the hallucination effect, or is that just the limitations of LLMs receiving input, or is it something else?
As far as the follow-up question and answer are concerned, it's doing the same thing. It's just being an LLM. It's just generating output statistically. It's not somehow turning it to its internal ethical code, suddenly remembering about its obligation of candor or anything like that. No, it's just being a stupid machine. By the way, GPT-4 is much better. I find it. I haven't seen it hallucinate at all, and it was able to recognize some leading cases on some issues. I think it's only a matter of time before OpenAI will do as well as specialized AI vendors, and then beat them by a lot, very quickly.
Does anybody else have a question for our speakers? We have a few more minutes. Oh, yeah, one sec.
Hi, I'm Riley Johannesson from Parry Sound. And so first of all, I'm a criminal lawyer, so I'm sitting here perhaps having some self-delusions, thinking that this isn't going to affect me, but maybe it just will, you know, a few more years down the road than you guys. However, I've been thinking quite a bit about this hallucination effect that you're talking about, and also about what happened. I've never even used ChatGPT or any AI. I've been thinking about the problems with coming up with case law. And is the problem that we organize case law and principles by case names, and so the computers, for want of a better word, are not coming up with the proper case name. They're coming up with essentially their amalgamation of, you know, all these different cases came to this principle, like the Greenwood and Smith and Jones, and you get that saying that that's the case of Green, Smith, Jones. Does that make sense? I'm wondering if the fact that we identify cases by person's personal names, is that what's kind of screwing up the AI?
I'm sure that contributes to it in some cases, and I'd be interested to know what Jordan and Pulak think. But you know, and that may be an issue because you know, if you're looking at ChatGPT, its data is not going to be structured in the same way as a data set that would be structured with a curated, you know, service. So if you know, there's a gazillion R.V. Smith's cases, but that's why we have uniform legal sites. So the issue of getting the wrong case, you know, is solved just by the uniform kind of legal citation. But it certainly is the case that it doesn't, you know, it wouldn't have an annotated statute that it could say, okay, well, that's what this case is, and this is the summary of that case. Okay, I know that it's the same one. But I think it's a bit deeper than maybe just the name issue.
Thank you.
Any other questions in the room? All right. Thank you very much to our three speakers.
Thank you.
Jordy, Scott, Pulak, very interesting material. Thank you very much.